Good evening. Welcome to Pros and Cons of Virtual Jury Trials. We are so excited to have so many of you with us tonight. We're going to respect your time, so we will definitely end our prepared program within 1 hour. Directly after that hour, we will go into our live Q&A. We did receive a number of questions prior to tonight, so those will be incorporated into the program. Without further ado, I want to introduce our esteemed panelists. And I think that this is actually going to be the hardest part of the night for me because I could go on and on about each of the guests, and we just don't have time for that. So first up, we have the Honorable Judge Verda Colvin. Judge Colvin was sworn into the Georgia Court of Appeals this year, and she is the first Black woman to be appointed to the Georgia Court of Appeals by a Republican government, which is no small feat. Next, we have Douglas Burrell. He's a senior equity partner at Drew Eckel and Farnham, and he's been a trial lawyer for nearly 25 years, and he will be president of the Defense Research Institute, commonly referred to as DRI, in 2021, just kidding. And then we have powerhouse trial lawyer Laura Johnson Bailey. Laura is the director of litigation for the Mabra firm. She has worked on both sides of the V and frankly has tried more jury trials than anyone I know. And last but not least, far from least, is Joe Murphy. He is a senior neutral at Miles Mediation. Joe, of course, also has a very long career as a trial lawyer, and he and I happen to have had a sweet little article that came out in the Daily Report today that speaks to a lot of the issues we're going to address tonight. I am Winter Wheeler. I'm a mediator and arbitrator at Miles Mediation, and I'm going to be our moderator today. So, we all know that COVID has caused an overwhelming backlog of cases in our court system. So there was actually another article in the Daily Report today, and it said that there hasn't been a significant change in the number of state court cases filed, but there has been a drastic decrease in the number of cases that have closed out. So what I take away from that in the broadest sense is that lawyers want jury trials, or at the very least, they want or need the pressure of that looming jury trial date. And sometimes we call that the jury trial hammer. Wow. So the technology to hold virtual jury trials exists. It does. So we can technically make this happen. But the question is, should we? Or are we going to lose too much in the translation? So let's get started. And first up, I would like to talk about jury selection. So I'm going to call on Douglas. And Douglas, I'm going to you first because I know you have some strong feelings in this area.
Thank you, Winter. I'm against virtual jury trials. And a lot of it is because of jury selection. I strongly believe that part of jury selection is the ability to look someone in the eye directly, to know that you have their full attention, to read their body language as not only you're asking them questions, but opposing counsel's asking them questions. And without that personal, physical, in-person interaction, I think you lose the ability to, and I don't believe that we deselect jurors. I believe we pick jurors. And so I believe you lose the ability to pick jurors that are going to really pay attention and give a fair assessment of the facts of the case.
Absolutely. And so, you know, in my research into this area, many of the court systems who are, that are thinking about going virtual One of the things that they're doing is considering having smaller jury pools, just out of necessity because of, the bandwidth, and, what can a server handle. They're considering smaller jury pools and limited peremptory strikes. What do you guys think about that?
Well, personally, Winter, I think that's a very dangerous situation to be putting our clients in. You know, the last several trials that I've had, I've made no less than 10 to 15 peremptory or motions to strike for cause. And so if I don't get those motions to strike for cause granted, because the judge is like, well, we got to have at least 6 or we've got to have at least 12, depending on the size of the case. Not only is he or she not going to give fair consideration to those motions to strike for cause, not necessarily because they don't want to be fair, because by and large our judges, especially in the metro area, they're overwhelmingly fair, but their concern is always, how am I going to keep my docket moving? And that's a legitimate concern for them. And so if they're striking out their entire jury panel for cause, then we've got to come back another day. But in the same respect, if I'm forced to burn what few peremptory strikes I have because I didn't get my cause motions granted, then is my client really getting a fair trial?
Another consideration is if you have a smaller jury pool, are you really being representative of the community? That's a constitutional right that all defendants have, whether it's civil or criminal. And so if you lessen the numbers, then do you ensure that you have that same quality of jurors representing the whole community? And so that could be a basis for an appellate issue.
I like well, first of all, I agree with Judge Coven. And as a defense lawyer, I want a broad section of the jury pool. I don't believe in stereotypes. And so you could have some people who maybe, because of their socioeconomic circumstances, do not have a computer and cannot participate in a virtual jury trial, but they could be very religious and conservative. And that's someone that in person I would keep and want on a jury, but because of socioeconomic problems may not be part of the pool when it comes to a virtual jury.
And to build off of what Douglas had said, as a plaintiff's attorney, I have clients who are so economically challenged that they're having to choose between their Medicaid copay to continue to get treatment and having food to put on the table. And so I want a jury pool that mimics or at least has an inclusion of the same socioeconomic class that my client is. Because if you've never had to choose between going to get necessary medical care and putting food in your stomach, then you don't really understand what my client is faced with and why he might have a legitimate reason for having things like gaps in treatment that my esteemed colleague, Mr. Burrell, loves to talk about during trial, because I used to do it when I was defense counsel all the time. So
thank you for admitting that you did, in fact, of course, do that, Laura.
I would tend to agree with all y'all, as they say, but I would think, as a defense lawyer for 20 years before I switched sides and then got in the middle, as a defense lawyer, my instinct initially, Douglas, I think would be the digital divide might create a situation where most of the jurors would be, the more effective jurors would be more conservative because they would be the ones with better Wi-Fi, an isolated room to become jurors. That if as defense lawyers we're looking for people that are more conservative, it seems like it could fall that direction. Now, I'm more like you as a defense lawyer. I always wanted a more diverse pool of to pick from, because I think a broader group of people makes a better decision. But I do think if you have a very short-minded, two-dimensional type analysis from the defense perspective, you might look at smaller juries and juries that are divided along technological capabilities, that some of the clients that Laura talked about who are more disadvantaged would find less of their peers among those that would pass the muster.
So Joe, I'd just like to talk about that, because here's part of my thinking. Who do we know who are better technologically? Millennials. And who does it appear tend to be a little bit more liberal? Millennials. I want people who can balance out those millennials who may be more in Laura's court than mine. And so I want the broad spectrum, because then I can at least understand their perspectives and make decisions on striking, as opposed to having a panel of technological savvy millennials who may be more liberal than I want them to be on a jury pool, that I may be asking them to make a decision about. So I want the broad spectrum more so than anything. I think if a defense lawyer believes that a smaller panel is going to help them, I think they're looking at a situation that may boomerang on them.
We've got a question that's actually, I think, very important. Douglas and I typically specialize in civil cases. I know Douglas has a lot more criminal experience than I do. But we've got a question. Does anyone have criminal clients in jail right now sitting without a bond? It says, I have 12 to 15 clients in jail waiting for a jury trial. So my options are wait for a vaccine, have at least a virtual voir dire, or have clients sit in jail for the next 18 to 24 months. And he says, please don't reply, get them a bond. 3 are accused of murder and not getting a bond. And I think that's that is the most important reason why we have to try to figure out a way to get jury trials moving again, is particularly these criminal clients. And it's a very good point. The last thing you want if you're accused of a crime that you don't admit to is to sit in jail for the next 2 years while you're waiting for it to be safe for jury trial, which is why I know Florida, down in the 11th Circuit of Florida, down in Miami recently, did their test pilot for a jury trial where they did the voir dire virtually and then had the jurors come in socially distance and wear masks and things like that during the trial in person. I know that we're going to cover that, but as far as maybe agreeing to a smaller panel, specifically with the consideration of criminal cases.
Yeah, I mean, I'm sorry, Larry, I didn't mean to cut you off, but I would really love to hear from Judge Colvin on that issue, as someone who has dealt with criminal issues to a great extent, obviously. Because we got here because we obviously need a solution. We need to help people figure out what to do. And so, most of us here on the panel, we are civil lawyers. So how do we help our criminal defense and prosecutors?
I've been thinking a lot about this since I haven't been long from the Superior Court bench, and I was known for moving my docket. And some may not like what I'm about to say, but I think at some point we have to be willing to move beyond where we are and to do something to get people their day in court. And I think it requires thinking outside of the box. I was thinking about it as Mr. Burrell and Ms. Bailiff were talking about the jury panels. We may have to bring in several panels over a course of days if people still want to have the ability to have a wide variety of jurors to choose from. But at some point, we are going to have to move forward. And I know the case that Ms. Bailiff was mentioning in Florida, they used the plexiglass to protect certain people within the court system. And I think that's the way we will have to do it. Maybe we can think about a hybrid where the jury is virtual, although I know counsel won't like that. And then the other parties are in the courtroom because of confrontation clause, effective assistive counsel claims. But I think at some point, particularly as we move into 2021, we're going to have to begin to push that envelope and figure out ways to move forward.
Judge Colvin, if you remember when we talked before today, the thing we talked about is, some type of creative solution, whether it is going a hotel ballroom where everybody can be spread out more. You lose some of the gravitas of being in the courtroom, But, that could be one of the ways to get criminal trials going again and yet keep people socially distanced. So, I think there's other ways than virtual that I certainly would be, as a former prosecutor, I would have been comfortable with doing something like that. But I do agree, we cannot have criminal defendants sitting in jail for unusually long periods of time. Something does have to be done.
Well, I think the biggest concern for me with doing a hybrid type trial where the voir dire is virtual and then the trial is in person and, socially distanced with masks and sneeze guards and things like that, it is the fact that I do think that because I watched they broadcast the pilot trial on YouTube and I watched it. I watched the jury selection process. And aside from the fact that it was incredibly tedious, I mean, they had a separate judge and a separate IT person from the courthouse for the sole purpose of getting people set up so that they can literally make sure their video's on, make sure their audio's on, make sure they're in a quiet place and all of that kind of thing. And they had jurors admitting, I'm sorry, this is the first time I've used Zoom. I don't know how to do this. And it was difficult for them. But the thing that struck me the most watching that voir dire, the virtual voir dire, is that it did seem like it gave the jurors a lot more leeway to not only not pay attention and do other things, but also not be as candid as they are in person. It's hard enough to get jurors to open up and really answer questions that the answer is probably not going to be very popular with certain parts of the room. But in person, you do have, as Douglas said, the gravitas of being in the courtroom and having the judge in the black robe up on the bench. And, you're sworn to tell the truth and voir dire. And so, there's a little bit of the intimidation factor to get people to be a little bit more honest and a little bit more forthcoming. But what I saw with the virtual voir dire down in Florida was that there was one dude in scrubs and he was obviously in his office at his job and he was turned to the side and working on his computer, and it was hard to get answers from people because they weren't being as candid as they would be if they were in person.
I would agree with Laura. I mean, we all know that once communication becomes abstracted, it becomes altered. I mean, just think of what people will say or do on social media that they wouldn't say or do in person. I mean, abstracted communication has changed the way we communicate with each other. I'm gonna try to take the other side of something for a moment, just to get a little back and forth. Are there advantages that we might see with a jury? Because as Laura says, they're more in their own environment, so they're more easily distractible. But are there advantages that either counsel could obtain or that the jurors could have by feeling I'm in my own home? Maybe I'm more comfortable. Maybe I'm more at ease than I would be, taking public transportation or my own car to try to park down at Fulton County to get out and fight the traffic and get into the building and go through the metal detectors and be herded around with a lot of other people. That whole process can make people so nervous by the time they're sitting down in judgment of a case. Maybe they're already distracted that in their own home, maybe we get them more as they are and more as they really are. I'll know as a mediator, mediating with people that are in their own homes, often what's in the background of that shot tells me something, gives me a little insight into that individual. And maybe if there's a bunch of books behind them, they read a lot. If there's, if it's a 80-inch television, maybe that's what they're doing with their time. And you learn things about people. Maybe as a lawyer, there's a lot you don't see, but maybe there's some things we would see observing jurors in their own environment we wouldn't otherwise. So I'd like to ask the panel, do you see tactical advantages for counsel or maybe some advantages to jurors of being able to do something more in the comfort of your own home?
Well, in Miami, the case that Ms. Bailey mentioned, they talked about the participation of jurors was actually higher as a result of that. And I don't know if because maybe the millennials, as Mr. Varel said, maybe they were the ones chiming in, but they had a lot of participation. And so they were kind of surprised about that. So I guess it depends on the community you're in. Miami-Dade, that's a metropolitan area. Probably most people there may have access to, web and internet access, whereas South Georgia, you might have more of a problem with that.
Yeah, and I'm glad that you bring that up because I think that the big problem that we have here in Georgia is we have a very stark rural versus urban divide, right? And I think for people like me sitting here in my house in the one of the many Marietta annexes to Miles Mediation, it's hard for me to even imagine that there are people who, even if they wanted it, can't have broadband access because it's simply not available where they are. So, you know, I think that this goes beyond, or at least to a more basic level than, are they paying attention when they're in their house? How do we even get Georgians to participate? How do they physically get to participate if they don't even have broadband? If they don't have the tablets, they don't have the phones, they don't have the computers. How do we get those items into their hands? How do we get them on the internet? And Georgia does not seem to be prepared, or there, and I've seen no indication that we want to get prepared to provide those things. And even if we wanted to, it would take an inordinate amount of time to send broadband out to every portion of the state. So we're looking to solve what, God willing, is a short-term problem, but that is going to take a very long term to try to fix. So I don't know how we get there. I don't know how we get there. Anybody have thoughts on how we get there?
Here's another level to that, though, Winter, is not just that the potential jurors might not have access to broadband internet or a fast enough connection to actually participate. I've tried cases in courthouses in this state, specifically South Georgia, that don't have Wi-Fi, that don't have good AV in the courtroom, much less, you know, access to the technology for the courthouse staff to, you know, handle this. Now, here in the metro, we've got, you know, judges who have, you know, YouTube channels. I know that DeKalb County, Judge Lopez and Judge Jacobs have both really embraced moving their dockets along with at least virtual hearings, by having, you know, the litigants log into Zoom and then they broadcast it to their YouTube channels. And then I know that Fulton County has, you know, their live streamed hearings as well. Because I tried watching a hearing not too long ago that got canceled at last minute. So there's also the issue of some of these courthouses don't have the technology to actually be able to participate themselves, the judges. Now they might have it at home, but they don't have it at the courthouse.
Right. So we have another question that came in. It says, I saw that video voir dire from Florida. Next question. Is the judge okay with a motion for change of venue from Barrow County to Polk County if Polk is ready and up for jury trials?
I think in light of what is going on now with the pandemic, any judge, being a jurist who's about ensuring that justice is administered, would be agreeable to having a case transferred to another county. That judge in the other county can allow them to sit on their bench and they can still hear their own case, but it would be in a county where that could be done. And so I don't see that as a problem whatsoever. I know as a Superior Court judge, when I was on the bench, I wouldn't have a problem with that because we all want to help each other move our cases along.
And I think that brings up another issue that we talked about before as a group. You know, out in these rural counties where you may not have access to a building large enough to go into where you could socially distance, for example, for a trial, and moving those things to a county where you can, you know, can we just readily pick up and move? Do you think that lawyers will agree to that?
That's one thing I was going to say. You know, you have the right to be tried in the county in which you've been charged in. So I guess the question would become whether the parties will agree to do so, because trying to move the jury from one county to the other county would be expensive, would be beyond the contours of what we do in a pandemic. And so you've got all those considerations. So you would probably want to entertain moving a case from one county to the next that is demographically similar to the county where the crime or the suit was actually filed originally.
Right.
And I'm not
You know,
gonna say our
there's another,
profession
Oh, hold on.
sorry. I was gonna say wasn't gonna say our profession is resistant to technological change, but I do know that a lot of law firms continue to use WordPerfect about 20 years after it stopped being supported by its manufacturer. So there is a reluctance in our profession that may be eroding as younger people enter it, but we tend to like to do things the way we did yesterday. You know, we call plagiarism precedent in our business. You just do it the way it was done before and you're always safe. A lot of this, all this stuff we're talking about would have to be done by consent. Constitutional guarantees for both criminal and civil jury trial mean that every step that we've talked about is a step that you're taking on your client's behalf away from something that's guaranteed and worked before.
well, the other thing we have to think about is judicial funding. I mean, we all know that there's a lack of judicial funding, not only in this state, but, you know, just about every state in the country. And how much will it tax the system financially if we're trying to do change of venues, to get up to speed, courtrooms up to speed with technology, or to bring in extra people to help try cases. So funding is a big question in whether we can go forward with all of this.
And Douglas, I would add to that, the other elephant in the room is funding for schools. We know whatever is going to happen next month with schools, it's going to look very different. And a lot of the plans would involve technology money going towards classrooms. Classrooms probably over courtrooms in terms of how most people think it impacts their daily lives. So it's a dollar that's not there to spend and it's someone else wants it first.
Absolutely. And I think another thing that we need to talk about is like something that I always thought was fun as we were preparing for trial is like finding that like special piece of evidence, that special exhibit, and, you know, you were going to surprise the other side with it, right? I think we lose a lot of that. Douglas, I think that you had talked about, you know, having a personal injury plaintiff and you know, how they walk to the witness stand or some, I don't want to mess up your story, but it was something like that. But we lose all of that, right? We lose all of that.
We lose the jury's ability to assess the witnesses, not only the plaintiff or the defendant, but all the witnesses. And, you know, I believe trials are all about credibility, what you believe, what you don't believe, what you see, what you don't see. And to be able to assess the witnesses in person is a critical element to a jury ultimately rendering a verdict. And the other personal thing that I think is extremely important is a jury scares me, an individual juror scares me if they won't look at me when I'm making an argument. And if they're virtual, I don't believe I have the ability to connect with them. And the way I connect is I give them a respectful distance, but I will literally move in front of that particular juror if they won't look at me when I'm doing the opening or closing, and I will stand in front of them until they look, we make eye contact, and I know they're listening to what I'm saying, and then I move on to the next one. And so I physically put my body in front of each individual juror to make sure that we can lock eyes and communicate non-verbally and verbally. And I think you lose that with a virtual trial. And I think that's critical. At least from my perspective, that is critical.
I would agree, not only just with, you know, openings and closing arguments, but also, you know, my trial partners have teased me in the past that I get these awful coughing fits while I'm sitting at my table waiting for evidence to come out. And it's because if I see a juror who might be dozing off or not paying attention, you know, that sharp, loud noise of, oh, cough, cough, my throat is so dry, is going to get their attention so that they're actually going to hear this nice tidbit of evidence that's about to come out, whether it's in a doctor's depo or in a certain portion of a witness's testimony or cross. So you really lose a lot of that when they're not there in person.
One thing I was thinking of after we had talked the last time was that if a jury is virtual, one thing that would be hard for a trial judge is to look at all 14 of those little boxes to make sure everybody's paying attention while also being attuned to the testimony and any objections that may be lodged by either side. And so I was thinking through, how do you navigate all of that as a trial judge to be attuned to 15, 16 different things going on at the same time? That's another thing we have to think about.
I think that brings us to another point too, because for the attorneys, like attorneys who have larger staffs, who have more money, they have more help with that. They have better equipment. They have larger screens. They're better equipped to see all of those things. So we've got an economic divide happening in the courtroom between the attorneys, right? So not only with the attorneys, but of course also with the jurors. I mean, we've got economic divides happening all over the place if we start talking about virtual juries. And I don't know how we get past those things. And so one issue that really gets to me is that the pilot programs that I've studied, they all require jurors to swear or affirm that they are alone in a room for the duration of the proceedings. And so, of course, that means you have to have the wherewithal to be alone. You have to have the funds to be alone. You need to have a home with enough rooms where you can be alone, or you need to be able to afford to live alone. And so that cuts out a lot of people, a lot of low income people who need to live with multiple people in order to have a home. We all know that the minimum wage in this country makes it impossible to live in any major city by yourself. So, we've essentially eliminated an entire class of people from our juries. What do we do about that? I'm not quite sure. And so, we've also got, people who are home working or who are taking care of the elderly or their children. And, God love them, but I have 4 children and I have plenty of room, but they're still everywhere. So, it's just difficult. How do we even make sure that we can accomplish that simple task? Because we have to have secrecy of the proceedings. We can't have external factors and third parties influencing our jurors. What do we do?
Well, to be perfectly honest, I think we don't do a completely virtual jury trial. I think the way that Florida has tried to handle it with a virtual voir dire and then bringing them in with social distancing and sneeze guards and wearing masks and all of that is probably the safest way to go about doing a trial during a pandemic while still preserving people's rights and their access to the courts. I know that there was an article that just came out where the judge had ruled that the socially distanced individuals in the courtroom, especially the witnesses on the stand, had to wear clear masks or like a face shield as opposed to a mask, so that you don't run afoul of the confrontation clause and so that the jury can actually see the reactions of the witnesses. Because think about it, like half the time that you spend on a Zoom conference, you're looking at either yourself or other people's boxes. And who's to say that you're actually paying attention to the witness who's being questioned? Who's to say that you're paying attention to the plaintiff or the defendant rather than, oh, that one juror down in that one box over there, he's kind of cute, or what in the world is she doing, or that kind of thing. So how do you know that they're actually paying attention? I think the answer would be that we have to have the actual trial in person with social distancing sneeze guards, things of that nature to keep people as safe as possible. But also making sure that you're not turning it into a kangaroo court.
Well, Laura's right. Those of us who've been using Zoom for some time now have figured out how to look like we're actually looking at the camera, and maybe we are, maybe we're not. You don't really know where anybody's looking. Someone had posted on Facebook the other day. It said, "I don't know why I need to do conferences by Zoom. I could just do them over the telephone while staring into a mirror because all I ever look at is myself." You tend to look at your own box a lot for some reason. I try not to, but you're right, Laura. Who knows what these people are really looking at? I'm generally looking towards this screen. Which one of you am I looking at right now? You can't tell.
You're looking at yourself. I know you are.
You know I am. You know, but you know me better than most, Winter.
Well, I'm concerned that people are going to Google certain concepts or people, things that they wouldn't be able to do if they were sitting in the courtroom, or they would Google, things that they're just interested in that have nothing to do with the trial. And those are things that you can't know about and cannot control, either during the trial or during the jury deliberation process. And so how much attention are they paying to the trial as opposed to other things? And
Well,
realm.
I'm sorry, Mr. Burrell. I'll be the devil's advocate on that. I think that still happens even in jury trials. So one day I had a juror come in. We're almost at the end of a trial with a pro se defendant. So that is extremely courageous to get to that point of a trial. And one of my jurors brings in a newspaper, despite the fact that I have said don't bring in newspapers, and read it to the whole jury panel. So I think that can does happen regardless, even the Googling. They go home at night and someone will look at something, but we find out because they say something to another juror. So that is a point, but I think we still have that even with traditional trials.
Yeah, but I think that there's a big difference between going home and Googling it and Googling it in real time. So, I definitely think that there's a difference. But what I've read for these pilot programs is a lot of them are considering providing technology where those items are not available on that particular tablet. Like that tablet only allows you to watch the court proceeding. Of course, that doesn't keep you from using your computer if you have one that's next to you. It doesn't keep you from watching your television. It doesn't keep you from interacting with whoever may be in your house. You can only provide so many safeguards, but if someone wants to be a jerk, they're going to find a way to be a jerk. So I don't know what we do about that.
More importantly, where is the court system going to come up with the resources to get all of this technology to pass out to 36 to 50 potential jurors? Because last time I checked, there are courthouses in this state that don't even have AV in the courtrooms. How are they going to pay for that?
That's very true.
Well,
I don't have an answer.
I guess to a hammer, everything looks like a nail, but I am a mediator and an arbitrator, as Winter is. And back to the theme of lawyers do like what they know works and has worked in the past. And to that extent, as we're talking about this novelty of virtual jury trials, the thing that has converted well to virtuality has been arbitrations and mediations. We found that to be a very smooth transition because, again, we don't have in walks the general public. We haven't gotten to it yet in our discussion, but as Douglas mentioned, he's probably most concerned about the voir dire process. I think my concerns with the jury process come at the other end during the deliberations, where they're really on their own. I mean, in a real-time, real-world, three-dimensional deliberation, they're behind the door. We're worried enough about what's going on in there. You put them behind a virtual door, and it's real scary. So I would just like to remind everyone watching, virtual mediations and arbitrations are up and running and going. They're tried, they're true, it's not risky, and don't forget that is still in the mix.
You know, one of the things that bothers me though about virtual deliberations that we don't have a bailiff. Even if we had a virtual bailiff, like how effective can the virtual bailiff be? You know, like I said a minute ago, you can't account for everything. If someone wants to accomplish something, they are going to accomplish it. There's only so much the bailiff can do. If I'm a juror and I just don't want to be in the camera frame, I get up. I walk off. What are you going to do? Are you literally going to come out to my house? Okay, maybe you could, but how much money are we going to spend doing that and policing people's actions? It's a complete waste of time, a waste of money. How long are these trials going to end up going?
And the bailiff couldn't be in the virtual room anyway.
Right. So what I would imagine is kind of, I guess, what we have going on here, where we have a webinar and there are people in like the back, the virtual back, running it. But I don't know. I mean, I don't really know how that works. I'm not technologically savvy. I'm just a mediator, and so I don't really know. But there's got to be some way someone could monitor what's happening. But no, you wouldn't know what was going on inside the actual meeting. So, if someone's power goes out, or their connection is bad, or they just happen to miss something, who knows? And is there, do we lose a lot of the camaraderie? I think we definitely lose a lot of the camaraderie between the jurors, because they're not together. They're not meeting in the morning and having that cup of coffee. They're not having lunch together. They're not chit-chatting about each other's kids. When they take breaks, they're turning off their camera, they're muting themselves, and they're going into their kitchen. There's no camaraderie with strangers who are just listening to information from a two-dimensional screen. So I think we lose a lot there.
Not only that, but one of the problems that the pilot program down in the 11th Circuit of Florida ran into is jurors not coming back from breaks, not logging back in from breaks. And they had to wait on one person while the court tried to track them down for over an hour, because they were well into the jury selection process and they couldn't just move on. They had to address it, and it caused a huge delay in everybody else's time, and money was affected by it.
It's probably far too tempting to not want to take that day off from work, right? Because if I can do my job remotely and do my jury duty remotely, I'm going to do them both simultaneously. And so, but if something comes up with work, maybe I can't log back in right away, or I lose track of time. So that could very well be what happened with that juror.
My problem, I think my biggest concern with going with a totally virtual jury trial where the jury is deliberating virtually as well is like Judge Colvin said, you can't have anybody in the room with the jury while they're deliberating. So how do you monitor to make sure that people are actually participating and in screen, and they don't just get up and walk away? Because that then raises some constitutional issues, which is going to make Judge Colvin even busier than she already is.
Yes. And one thing you said, I guess they would do just like we do in a live jury trial. If they have an issue, then the foreperson would, I guess, knock on the virtual door, tell the bailiff what the issue is by writing it down someplace, and then come to the judge. So I guess in that sense, it could be the same, but you're right. It's just no way of monitoring all the different nuances that can occur when they're in their individual homes.
Absolutely. Absolutely. And so, of course, being a former legal malpractice defense attorney, the obvious questions come up for me. Who are the lawyers that are going to agree to allow their clients to be the guinea pigs for this? Who in my little boxes that I can see here would do that?
No, I'm out. Sorry, it matters too much to my clients to have a fair trial, because I'm no longer gambling with a big corporation's paycheck or checkbook, I should say. I'm gambling with my client's well-being. And I can't in good conscience be that cavalier with their one shot at rectifying a wrong.
Right.
I can't do it either from my client's perspective. I just think there's too much unknown that can lead to appealable issues. I think the people who you're going to see try this is on the criminal side. Like we heard earlier, a criminal defense attorney who has their client sitting in jail for a year or more. And do you want them sitting in jail, or do they want to have a trial? I think you're going to see that more than you're going to see it on the civil side.
And I saw we had someone who chimed in and said they were willing to do, criminal defense attorney, willing to do a virtual jury selection, but that would be the only portion that they would be willing to do. Maybe that's how we move forward. When counsel are concerned about their clients sitting in jail for long periods of time, I think the state would have a hard time objecting to such if the defense is willing to do so. And so depending on how long this pandemic lasts, I would imagine at some point we'll start venturing down those waters, and then the appellate courts will have to decide, what is enough.
Especially with sheriffs trying to figure out how to socially distance in their jails. I mean, if any place is a breeding ground for a pandemic, it would be a crowded jail. And how do these sheriffs ensure the safety and the health of not only the people that they're charged with caring for and keeping in one place, but also their own employees?
A big part of what Judge Colvin just said, and you said a lot when you said it depends on how long this lasts. And you can only kick the can so far. Like Douglas said, if you're 6 extra weeks in jail, that's bad enough. If you're 2 extra years in jail, I mean, that's this compounds exponentially. And I had the opportunity to put pen to paper with an article that was in the Daily Report right at the beginning of this, around April. And the question there was, how long is this going to last? And I don't know that it's really changed. I mean, the thought then was it's going to be a period of time when there's a vaccine that's been developed, been tested, been utilized, made broadly available. And probably now we know vaccines, not vaccine, and most of them would require multiple inoculations. So you're talking about something that would have to unroll at such a massive scale before you would really get to the point where the government can compel strangers to sequester with each other, much less assemble in large groups of hundreds. So unfortunately, this is not a short-term or even a medium-term problem. I mean, the life of a lawsuit should be inside of 2 years. We may be 2 years before civil jurors are really freely assembling again. And I would love to know y'all's opinions on that in terms of how long. I know judges sometimes don't want to speculate about these things because you've got Chief Justice Melton sort of speaking for the group, but I'd be interested in knowing y'all's thoughts on that.
I personally do not think that there are going to be any civil jury trials until after the first quarter of 2021, and that's assuming that there's a vaccine that is found and that starts to be distributed at the beginning of the year. If it takes longer, then I think it's going to take longer to have any jury trials. And then, of course, criminal jury trials are going to take precedence before civil. So, I think it's going to be a long time before there are civil jury trials.
And I saw a question pop up, but then it disappeared. I think it was something to the effect about appellate courts giving some advisory direction, and typically they don't. I mean, we have to wait till an issue comes before us to review before we give some direction. And one of the articles that I read says something to the effect that, there may have to be some guinea pigs so that courts can become involved and give some direction on what is the bar and what has to happen, what's the lowest rung we can go on the bar to give people their constitutionally protected rights. And so we'll have to wait till someone's willing to do so.
Well, and then the question becomes, are those cases going to be expedited through the appeal process? Because if they're not, then everything's in limbo until those go through. Because I can tell you, I would not want to try a case until there's a ruling from the Court of Appeals or the Georgia Supreme Court on issues that are brought up in a virtual trial.
And I'm low man on the totem pole, so I can't speak to that directly, but it stands to reason that there would be something that would be done to accommodate that, because of course, if you don't, then you have this avalanche of cases where people are waiting to see what's going to happen to know which way to go. And so all of this is uncharted territory. Who knows where we might go and what might happen. I am just hopeful that a miracle will occur and we can somehow get back to some normalcy, because otherwise it is what we're talking about, a mess. It's just, full of problems, appellate wise, as well as for counsel.
But of course, I volunteer as tribute to mediate all the civil cases.
So there's your answer for civil matters.
I think we're talking in terms of short term, but I think this also warrants a long-term discussion once COVID's over with courts and trial practitioners about what we're going to do in the future if something like this happens again and how it's going to be handled. I think this is going to require lengthy study, because I'm not sure that this is the only pandemic that we're going to go through. In the next 20 years, there could be something else, and we cannot be in the position that we are now without a healthy plan in place to deal with it.
I totally agree.
I think one of the biggest trends I'm seeing is, we had already had, especially in the metro, a trend of most of our judges requiring that cases be mediated before they're placed on a trial calendar. I think you're going to find more consistency in that regard as we continue to muddle through this and try and figure out a way to handle it, because it is one way to try and move a case while we can't get a jury trial.
One of our listeners asked about speedy trial demands and the fact that I think it was he may drop 10 to 12 speedy trial demands soon, and what will happen with those? That's a question, and that probably will be a question that comes before an appellate court to determine what happens. I can't imagine the law would be such that we would put people's lives at danger, but then that will begin to address some of the things Mr. Burrell said about we've got to kind of come up with a plan, like what can we do and how will we deal with the constitutional requirement that the person has the right to have their trial and have it in a reasonable amount of time. And so all of those will be issues that we'll have to resolve somehow when I think it was Mr. Lawrence might drop those 10 to 12 speedy trial demands. That will become an issue that we will have to resolve unless that particular court system is ready to do some novel things to give that person their day.
Well, the other aspect of it is I have colleagues and friends down in Florida who just yesterday had a trial on their divorce case. Now, of course, it's a dissolution of marriage, so it's a bench trial, no jury. Me as a civil attorney, I don't even want to agree to 6 jurors, much less no jury. What do y'all think about possibly handling your cases with a virtual bench trial? Because obviously there are certain courts in the metro area, at least, that have kind of really gotten comfortable with the technology of doing virtual hearings, and a bench trial would be very similar to that. The only, real challenge I could foresee with that is getting the exhibits to the court and being able to, manipulate them and address them. But what do y'all feel about possibly agreeing to a bench trial? I know I'm personally not for it.
I think judges would love it. It would help move their dockets.
Well, of course, Judge Colvin, you're for it. No, the answer is no. But as an aside, as far as exhibits and things like that, there are programs and apps and things that are functioning pretty well for that. But no, I mean, I guess if we were operating with a high-low agreement, I think we all had a conversation a couple of days ago when we were talking about high-low. But of course, that means you have to have the right case for that. So it's certainly not, it's not something that we could say, you know, we couldn't just have a blanket, oh, well, we'll just do all of these by bench trial. Like, we definitely can't do that.
I think the higher the stakes, the greater that I want a jury trial. And it's this simple reason. As a judge being the finder of fact, then we're looking at an abuse of discretion standard going up, which probably is never going to get overturned from my client's perspective as a defense lawyer. And I would much rather have a jury where I at least have legitimate opportunities to be able to appeal of adverse verdict.
I think we all agree on something, except for Judge Colvin.
I totally understand that. I did defense work, plaintiff's work before, so I understand those views. Of course, from a judge's perspective, we want to move the docket, so.
So guys, I feel like we didn't come up with a workable answer. So we still have the same problem, right? We've got all of these cases. We have injured plaintiffs. We have people who are in need. We have criminal defendants who are languishing in jails, sometimes unnecessarily, and we have no way to help them. We didn't have a plan or the right plan or whatever in place. And so this is where we are, and we owe it to our communities to figure out what in the world we are going to do next. I think that we have covered a lot of things here today. We've talked about a lot of topics. We've covered a lot of these questions, and hopefully we have sparked some further conversation amongst those who are watching. And I hope that they continue to go out and talk to their colleagues about all of this so that we can hopefully come to some kind of answer, because our community is really counting on us. Lawyers really have got to get it together and provide answers for our community. This is one of those rare times where everyone's actually looking to us and not necessarily joking. So that brings us to the end here of our program. And I want to thank everyone for being here. We do not have any open questions at this point, so we can close it out, guys. I want to say thank you to everyone who's here. My co-host, Joe Murphy, I'd send you, well, you know what? I'm sending you like a virtual fist bump or jazz hands or something COVID friendly. Yes, Wakanda forever. Thank you so much. Judge Colvin, thank you for being here. I really appreciate it. You definitely brought some insight that the rest of us wouldn't have had. So thank you very much.
Thank you for having me.
Well, thank you very much for taking the time to be here. You know, I always appreciate any time I get to ask you a question. So thank you very, very much.
Thank you for having me.
Thank you all.
And Laura Johnson Bailey, you know, you and I have been buddies for a long time. Thank you so much for being here. You're one of the first people I met in Atlanta, and you've actually taught me a lot. So thank you very much for imparting some wisdom on our viewers. It is officially 7 p.m., so we're gonna let everybody go. Thank you so much, guys.
Thank you. Take care.
Good night, everybody.
Bye.